course, yesterday, judges ruled that the sentence of a man who stabbed 3 people to death in Nottingham, that man, of course, was Valdo Calocane, a man who came to this country on a student visa and remained here. He was judged to be unfit to stand trial effectively. He pleaded guilty to manslaughter. Diminished responsibility was mentioned. He was sentenced, of course, to psychiatric care, psychiatric treatment in a hospital, which means that he could be released back into the community. The families of the Nottingham triple killer, the victims, have said the ruling is absolutely and utterly ridiculous and has handed them a life sentence. Let's talk to Simon Spence, KC, who's a barrister. Simon, a very good morning to you.
Good morning.
I mean, always difficult, these decisions for judges, I suppose, and you may be able to explain to me why it wasn't possible to find that this was an overly lenient case, because the families in the situation were quite appalled at the way the investigation was run, the way that things happened without their knowledge, the way that the police questioned this particular suspect in the case. He was allowed to plead guilty to manslaughter, which meant that he didn't have to face the likelihood of being sentenced to life in prison.
That's right. I mean, there are two separate aspects to this. One is whether the pleas of guilty to manslaughter on the grounds of diminished responsibility were appropriate to be accepted by the prosecution.
Right.
And the investigation into that concluded that it was, because, of course, there were 4 psychiatric reports, and they all unanimously concluded that diminished responsibility applied to the case. And so realistically, the Crown Prosecution Service and Prosecution Counsel had no choice but to accept the pleas that he entered. The issue that was before the Court of Appeal yesterday was the sentence that was imposed by the sentencing judge, Mr. Justice Turner, and whether it should have included a custodial element, or whether, for the better protection of the public, a psychiatric hospital order with a restriction was the more appropriate sentence. And the judge concluded that it was, and the Court of Appeal agreed with him.
So that means that he will still be able, if necessary, or if it happens to turn out that way, to be released, because I know the families of the 2 students who were murdered, Grace O'Malley Kumar and Barnaby Webber, they were very concerned about a similar case that had happened some time ago, a couple of years ago. A guy was sentenced to a similar, non-custodial sentence in a psychiatric unit because he had kicked some woman to death. But he was also judged to have had diminished responsibility, and despite the fact that they said he would be held for some time, 2 years later he was released because he was judged to be no longer a danger to the community. And I think that's what the families are concerned about, that in this case, Calocane may be able to be released sooner rather than later.
Well, there are 2 things about that. First of all, this is a very, very different case indeed. The paranoid schizophrenia that he is suffering from is said by the psychiatrist to be untreatable, and that means he will remain as dangerous as he was on the day of these killings. And so, that being the case, all of them are of the view that it's highly unlikely, in fact, that he ever will be released. There is, of course, a technical possibility, unlike a whole life order, which he would undoubtedly have got had he been convicted of murder. There is a technical possibility of release. But, of course, that decision is not one for the parole board, as it would be for a term of imprisonment. It's for a specialist medical panel who will be assessing his psychiatric state as the years progress.
Right.
And so when you think about...
Sorry, go on.
Yeah, when you think about protection of the public, whilst the parole board is made up of people from a whole wide variety of disciplines, it's not a specialist panel in relation to mental health, whereas the panel that deals with psychiatric disposals is. And so, in fact, the protection of the public is better served by a hospital order with restriction than it would be if he were in prison.
Yes, possibly so. But on the other hand, you might argue as well that if somebody is suffering from that level of schizophrenia, which will never change, on what basis is there any point in that person being put under psychiatric care? Because if there's no possibility of an improvement in his condition, then surely you're just better off locking him up.
Well, from one perspective, I can see that. The problem, of course, is that the regime in a psychiatric unit is much stricter in relation to medication and so forth. If he was simply put in prison, then he would be able to refuse to take his medication. His schizophrenia potentially could get worse. And within the custodial setting, both prison officers and other inmates, he would be a risk to them. And that was one of the matters that was concerning the Court of Appeal yesterday, having read the judgment, that they were concerned that in prison, he would be a danger to others.
Right.
And of course, the point was made by his barrister in the hearing at the Court of Appeal, rightly or wrongly, in this country, we don't lock people up for being mentally ill. We haven't done that for many decades.
No, but we do lock people up for being a danger to the public, though, don't we?
We do. And of course, putting someone in a psychiatric unit is locking them up, albeit in a different institution. And I've been to many psychiatric hospitals, and I can tell you, they're not a cushy number by any means.
No, I'm sure they're not.
The regime and the whole feel of the place feels exactly the same as a prison.
And is there also not an element here of the judiciary not really wanting the victims and the families of the victims to have a say too much? And I know that, you know, people go as far as they can to kind of get victim statements now read out in court and that kind of thing. But is there also not an element, I suspect there is, where people who run the judiciary and the judges in the system, they don't want to be kind of ordered around by people who have suffered as victims?
Well, they don't want to be ordered around. I think that's absolutely right. That's a very different thing from taking their views into account. But of course, any family which has suffered the absolute tragedy that these families have, by definition almost, are unable to look at the matter objectively in the way that the courts have to. Sentencing and indeed decisions about accepting guilty pleas to manslaughter as opposed to murder have to be evidence-based. You can't just say, well, what he's done is so horrific that we must pursue charge of murder no matter what. And whilst the courts have made huge strides, particularly over the last 20 or 30 years, in listening to the views of victims, at the end of the day, the court has to make decisions based on the evidence, even if that decision is unpopular, and even if that decision perhaps isn't readily understood by the public at large.
Yes. I mean, according to reports that I've seen, though, inside the psychiatric hospital where Valdo Calocane is going to be held, he will have certain things which he perhaps wouldn't have in prison. You know, he will be treated reasonably well. He will be able to have musical instruments. He can play the guitar. He can have a saxophone inside his room. He'll be able to watch DVDs, listen to records. You know, there will be people who will say, well, that's not... doesn't sound much like a punishment that a prison would be.
Well, there are similar facilities available within prison as well. You know, there are gymnasia in most prisons and recreational facilities and so forth. I think that the point in relation to Mr. Calocane is that, as the Court of Appeal said, but for his mental illness, he would not have behaved in the way that he did. And their view, as the sentencing judges was, is that treatment and protection of the public is more important than punishment. As I said a moment ago, you know, we don't punish people for being mentally ill. And if the mental illness is the only cause for the commission of the crimes, which in this case it appears to be, then that has to be the priority as far as the court is concerned. Of course, the whole process of unduly lenient sentences in this case is quite unusual because it does appear that there's no question that he'll ever be released. So the only question is what the environment that he's being detained in should be. Normally, with unduly lenient sentences, somebody gets 7 years when they should have got 15, for example. And they're more easy cases for people to understand. I think this one was rather more nuanced. And the Solicitor General who brought the case before the Court of Appeal was perhaps influenced by other factors rather than that the judge made a mistake in law.
Yes, that may well be. I certainly think that there was certainly a lot of public opinion that may have been brought to bear on the case as well. Simon, we've got to go, but thank you very much indeed for explaining all of that. Simon Spence, KC barrister. There